fundamental rights, right? They are fundamental rights. Now, if you take this concept of rights, so why rights are essential? First thing. Second thing, what is the significance of the word fundamental, right? So why we are using this fundamental? What do you mean by fundamental? Fundamental means those rights which are basic in nature, which cannot be destroyed. So fundamental means undestroyable, indestructible, right? So these are the basic rights. These are the basic rights. That is, those rights which are essential for healthy existence of individuals. So these rights are essential for healthy existence, healthy well-being of individuals. That means without these rights, it is not possible for the individuals to lead a healthy life. All right. So if you compare man, a human being, and an animal, so even human being is a part of animal. Then what is the difference between animals and human beings? Is there any difference? Now, is there any difference between humans and animals? Do animals think about dignity? Animals never think about dignity. But for human being, the basic nature of human being is to lead a dignified existence. Right? Health, that is, and as an individual, as a human being, we can lead a life only when we have all the freedoms, right? Freedoms which are essential to lead a healthy and a dignified living, right? That is the meaning of this fundamental. So basic rights which are essential for individuals to lead a dignified existence. When there is no dignity, then there is no meaning for rights, then there is no meaning for freedoms, right? So dignity is essential, right? So in order to promote this dignity, in order to promote a healthy life, our constitution has provided these basic rights, and these basic rights which are part of part 3. Remember, when we talk about rights are present not just in part 3 of constitution. Rights are not present not only in part 3, but they are also present in other parts of constitution. Right? So when we talk about rights, so these rights are present in part 3, in part 4, right? Not only this, right? Even we have this part 13, right? So here we have rights present in other parts of constitution. Then what is the difference between the rights mentioned in part 3 and the rights which are mentioned in other parts of constitution? All right. So if you take this difference, the rights which are mentioned in part 3 of constitution, they are guaranteed, they are justified. So there is a constitutional guarantee given, there is a constitutional justification given to the rights which are mentioned in part 3 of constitution. Whereas the rights which are mentioned in other parts of the constitution, there is no guarantee for them. You cannot question, you cannot claim them, right? So the rights, say, let me take the example of part 4 of the constitution. Rights are also present in part 4 of the constitution, but the rights which are mentioned in part 4, they are not guaranteed. They are not guaranteed. They are not justified. They are not guaranteed. They are not justified. That means if these rights are violated, if the rights mentioned in part 4 are violated, you cannot question them. You cannot question the government. You cannot question the violator, because Constitution itself has not guaranteed them. Whereas the rights mentioned in part 3, they are guaranteed. They are guaranteed. They are justified. These rights are guaranteed and justified. So remember, we have one constitutional provision, that is Article 32 of Indian Constitution. That is Article 32 of Indian Constitution. So this Article 32 has very much importance. Right? So it is through this Article 32 the entire fundamental rights are justified and guaranteed. Right? So this Article 32 provided constitutional remedies. This Article 32 provided constitutional remedies. Right? So remedies which are in the form of these remedies. Remember, These remedies, they are in the form of writs. We simply call them as writs, constitutional writs. These remedies are called as writs. Alright, so we have different types of writs. So there are 5 types of writs mentioned in Article 32. So these writs are used, these writs are issued to protect fundamental rights. Just now I said that the rights which are mentioned in part 3 are guaranteed and justified. How they are guaranteed and justified? By way of Article 32. It is by way of Article 32 where these fundamental rights are guaranteed. And this guarantee, it is in the form of constitutional writs. Alright. So that is the reason why B.R. Ambedkar, while describing these fundamental rights, he called Article 32 as bulwark of Indian Constitution. Article 32 is regarded as bulwark of Indian Constitution. It is regarded as heart and soul of Indian Constitution. It is Dil Ka Dhadkan, right? It is regarded as heart and soul. It is regarded as heart and soul of Indian Constitution. That means without Article 32, Part 3 is useless. Ante kada? When there is no guarantee, then what is the point in providing fundamental rights? Now, why we should call them as fundamental rights? There is no point in calling them as fundamental rights. Alright? That is so. Article 32 is very important. Alright? So, the rights which are mentioned in Part 3, they are guaranteed and justified. That means, if the rights of any citizen is violated, if a right of any citizen is violated, then the affected individual, that means the individuals whose rights are violated, the concerned individual can approach courts and they can claim for remedy. Now, where the individual can approach, to which court the individual can go? So, we have Supreme Court, we have High Courts, we have what you call local courts. Remember, whenever the rights are violated, the individual has the right to approach Supreme Court, not only Supreme Court, but even High Courts, because the guarantee of protecting fundamental rights, it is given to both the Supreme Court as well as High Court. So, under Article 32, it is Supreme Court that can issue the writs. Alright? Not only Supreme Court. Under Article 226 of Indian Constitution, even High Courts are constitutionally empowered. They are empowered to issue the writs. That means the affected individual, they can approach both Supreme Court as well as High Courts. Alright? Now, I'll ask one question. Now, without approaching High Courts, if an individual approaches Supreme Court, will the Supreme Court will provide the remedy? No. Because you have an option of using High Courts. Let you go to High Courts first. If High Courts fails to provide remedy, then come to me. Okay? Right? So, even though you have a right to approach Supreme Court directly, Supreme Court will advise you to go to High Courts first and then come to Supreme Court if you are not satisfied with the verdict given by High Courts. If you are not satisfied with the judgment given by High Courts, then come to Supreme Court. Say, for example, if a High Court denies what you call a remedy, if the affected individual has not got any remedy in High Court, then he has the option of going to Supreme Court. So that means, though approaching Supreme Court is a right of every individual, but Supreme Court will advise you to go to High Courts first, then claim remedy there. If High Courts fails to provide remedy, then approach Supreme Court. So we have Article 32 and Article 226 of Indian Constitution. Alright. So constitutionally, both Article 32 and Article 226 can provide guarantee to the fundamental right. Then what about district courts? Don't they have the power to protect the fundamental rights? Remember, a very important point to note for prelims exam. Alright, constitutionally, the district courts are not given any power to protect the fundamental rights. Right? That is, they don't have any writ powers. The district courts don't have any writ powers. But Parliament has every power. Parliament has every power to empower the local courts to issue the writs. That is, if Parliament by law empowers, right, subordinate courts. Let me use the word subordinate courts. Subordinate courts means what? Those courts which are subordinate to high courts. So it includes district courts, the sessions courts, right? Any other court, right? So these subordinate courts can be empowered to issue the writs. These subordinate courts can be empowered to issue the writs only when Parliament allows. When Parliament by law allows. So Parliament by law can empower the subordinate courts to issue the writs. So that means constitutionally they are not given powers directly, but they can be empowered by a law of Parliament. So constitutionally it is only Supreme Court and High Courts. So the rights which are mentioned in Part 3 of Indian Constitution, they are justified and guaranteed. Okay. So this is the first thing that you should know about fundamental rights. Right. So that means whatever we are discussing, it is about the features of fundamental rights. Right. So this is the first feature. So why they are called as fundamental? They are called as fundamental because they are basic to the existence of individual. They are basic to the healthy and dignified existence of individual. Right. So remember, Supreme Court in pavement dweller case, there won't be question paper both in prelims and mains without a question on fundamental rights, and that too question on Article 21. A question on Article 21. All right. So pavement dweller case, Francis Corollis, all right, Bombay Municipal Corporation case, right? So it is also called as pavement dweller case. I'll say one simple thing, right? In this case, so first let me complete this. So in this case, Supreme Court said that dignified existence is a part and parcel of right to life of individuals, right? So dignified existence is a part and parcel of right to life. The it is a part and parcel of right to life, right to life and liberty. So without dignity, is there any meaning to life? No. So dignity is essential. All right. Now, dignity of whom? Whether all citizens of India or only few citizens of India. All right. Then what about the people who are living on footpaths, pavements? Do you show respect to them? Do we respect them? No. Practically speaking, in reality, we don't show any kind of respect. We don't show any kind of sympathy. Pavement dwellers, right? The one who are living on footpaths, the one who are living on what you call pavements. Whether the constitution that is written, it is only for the people who are living in urban areas. Do this constitution is not applicable for the people who are living in slums and on the pavements? Constitution is for everyone. But in reality, where this constitution is applied for everyone? No, that is the reason why Supreme Court clearly said that every citizen of this nation has the right to live with dignity. When there is no dignity, there is no meaning to right to life. All right, that is what clearly said by, these are the words of Supreme Court in this case. It is not just mere animal existence. Human existence is not animal existence. There is a difference. The difference is we should live with dignity. Right. So fundamental rights ensures a dignified existence, a healthy existence. All right. So this is one thing. Now, I'll ask one question. So just now, by this time, I think you have got the importance of fundamental right. So what is the importance of this word fundamental right? All right. So now the question is, when these rights are such important, when these rights have such importance, so should they be restricted or not? All right. Should they be restricted or not? So can we call these fundamental rights are absolute rights? Whether these fundamental rights are absolute or not? Now I have a question mark. Whether fundamental rights are absolute or not. What do you mean by absolute rights? What do you mean by absolute rights? What do you mean by absolute right?
Sir, cannot be restricted.
Good. Those rights which cannot be restricted, unrestrictable, no one having the power to restrict them, we call them as absolute. Now, should these fundamental rights be absolute? Should we call them as absolute in nature?
Yes, sir.
Yes. Now, who is that? I don't know your name. Praniti. Okay. So now, because of their importance, you feel that these rights are absolute. Yes or no? Praniti. So because of their importance, we are calling them as absolute rights. Now, I'll ask one question. Absolute right means those rights which are unrestrictable. Now, when citizens are given unrestrictable rights, is there any guarantee that they will not misuse them? There is an every chance of misusing of rights. We have, all right, God has given mouth. We can talk anything. We can hurt anyone, right? We can talk against our nation. We can criticize our nation. We can criticize our constitution. We can, what you call, we can appreciate our friend, what you call, our enemy country. We may support our enemy country. Now, are you seeing these kind of instances or not? In our daily life, we are coming, we have come across these kind of instances. Now, what in case of these absolute rights? When rights are absolute, when rights are not restricted, that means there is an every chance where individual can misuse their rights. In such case, what to do then? There should be some kind of control on fundamental rights. There should be some kind of control. All right. So I'll ask one question. All right. From which country we have adopted fundamental rights? From which country? From which constitution we have adopted fundamental rights? So basically, it is US. It is American Constitution. It is American Constitution. America is what you call the first country to provide constitutionally provide what you call fundamental rights. Remember, even in America, rights are not absolute. Even American rights are not absolute. That means even American Constitution has allowed to control and restrict, impose restrictions on fundamental rights. And this power is given to judiciary there. In America, it is judiciary which was given the power. In America, it is judiciary that is given the power to impose restrictions on fundamental rights. So that means when America itself is imposing restrictions, what about India? So there is no chance. Even in India, restrictions can be imposed. Though they are fundamental, though rights are fundamental, they are not absolute. Am I clear to you, Praniti?
Yes, sir.
Alright, so that means though they are fundamental, they are not absolute. Right? That means the rights mentioned in part 3 of Indian Constitution, the fundamental rights in Indian Constitution, they can be restricted. Right? So no country in the world provides absolute rights, because providing of absolute rights is very dangerous. All right? It is very dangerous to society and nation. That is the reason why no country provides absolute rights. These rights are restricted. So next important point is, these are fundamental. All right. They are not absolute. They are not absolute. All right. They are not absolute. They are not absolute means what? They can be restricted. They can be restricted. Now the big question comes. Now what is that question? Who can restrict them? When they can be restricted? All right, you should know this. All right, so what are the what is the procedure, what is the criteria for imposing restrictions? So this is a very favorite area for UPSC. Very frequently questions are raised on these areas. All right, so now first of all, when restrictions are imposed, let me talk about the conditions or reasons for imposing restrictions on fundamental rights. So when restrictions can be imposed. All right, so we will talk about this. Now, do we have any constitutional conditions for imposing restrictions, or simply whenever required, restrictions can be imposed? Government power.
Act an amendment, sir.
It requires an amendment. So it doesn't require any amendment. Alright. So now we have certain constitutional conditions which are mentioned. So in our constitution, there are clear conditions mentioned. When that conditions are violated, then restrictions can be imposed. Not only this, right? If Parliament makes a law, right? If Parliament makes a law for imposing restrictions, by using that law, restrictions can be imposed. So here, when we talk about a law, that law might be concerned with some kind of conditions. Today we talk about UAPA, Unlawful Activities Prevention Act, right? We have UAPA, Unlawful Activities Prevention Act. Act means what? A law that is passed by Parliament. So already Parliament has passed a law. So there are certain things which are regarded as unlawful activities. So there is what you call some kind of what you call activities which are listed as unwanted activities. If any individual involves in these kind of unwanted activities, then by using this law, restrictions can be imposed on the individuals. Because now that is the reason. There should be some conditions. Either they should be mentioned in Constitution, or that condition should be mentioned in what you call law of parliament, right? So it is only this, right? If government imposes restrictions when it likes, then they are called as arbitrary restrictions. So remember this word. Such restrictions are called as arbitrary. Very, very, very important word. Arbitrary restriction, right? Arbitrary means those restrictions which are neither mentioned in constitution nor mentioned in law of parliament. So there is no place for what you call arbitrary acts. There is no place for arbitrary acts. Alright, very important టు నో. రైట్, ఇష్టం వచ్చినట్టు చేయడానికి వీల్లేదు. ఇష్టం వచ్చినట్టు చేయడం అన్నదే ఆర్బిటరీనెస్ అంటే. రైట్, సో ఐదర్ ఇట్ షుడ్ బి అకార్డింగ్ టు కాన్స్టిట్యూషన్ ఆర్ ఇట్ షుడ్ బి అకార్డింగ్ టు law. Without a law, without a constitution, government cannot act. If government acts, they will be called as arbitrary acts. Okay, so have you come across the doctrine or concept of rule of law? Rule of law, which is the backbone of Indian constitution, and it is backbone of what you call fundamental rights. A very, very important concept, rule of law. Very once in 3-4 years you will find this question in UPSC mains. All right, a concept that is given by A.V. Dacey, a concept that is given by A.V. Dacey, D-I-E-C-E-Y, A.V. Dacey, a British constitutional commentator. All right, so A.V. Dacey. All right, so here I'll talk about this concept later, but as of now I don't want to disturb our flow. So every restriction, right, that is, there are certain conditions. All right, there can be restrictions, but it should be based upon certain conditions. That means no arbitrary restrictions are allowed. No arbitrary restrictions are allowed. Right? So every restriction should be according to constitution or it should be according to law. Every restriction should be according to constitution or it should be according to law. Right? It is only then these restrictions are justified. Right? If restrictions are according to constitution or law, then it will be justified. If they are not, they won't be justified. Right? They will not be justified. Okay, so this is another thing. So what are those conditions? Right, I'll explain, but not now. So now who has the power? Actually I'm running out of time. So before ending my class, అర్థమవుతుందా? బాగా అర్థమవుతుందా? What about the people who are in online? Praniti, are you comfortable with the class?
Yes, sir.
Okay, so from tomorrow I'll start the class at 9:30 in the morning. So the class will be from 9:30 to 10:50, 10:55 because I have another class after this. Okay, so from tomorrow onwards, all right, I'll start the class in the morning at 9:30. So first I'll complete the basic features of what you call fundamental rights. I'll talk about the issue of what you call absoluteness, restrictability of fundamental rights, amendability of fundamental rights. Then I'll go to the individual rights. That is from article, I think you have been taught article 12, 13, 14, right? Where you are? 14 dagarnara. Okay. Okay then. So I'll start from article 16, right? So if you are comfortable, then I'll go ahead. Okay. So for now, you start the class. We'll meet tomorrow in the morning.